edition of MHQ's Foundation 101 podcast webcast, where today I'm joined for the second time by the excellent Stuart Patterson. Stuart, good morning. How are you?
Hello, Jan. I'm very well, thank you. It's a pleasure to be here.
Always happy to have you. So for those that are listening at home, they would remember that you and I did a little exercise around fiduciary structures under attack a couple of years ago. So you can go back to that webcast if you want the basis. And what triggered our reinviting you is an update. We talked all the time about trust and foundations being at the heart of successful wealth management structure and succession planning, but sometimes things do not go as well as planned. So what I wanted to have you is to shine a little bit of light and takeaways on this little case, La Dolce Vita versus Zhang Lan. So Stuart, would you mind giving us the context of this case, and then we'll jump around on the judgment and the key takeaways?
Happy to, Jan. Yes, and thank you. It's an interesting case and a good reminder of some of the basic principles that we need to think about. So the claimant was the marvelously named La Dolce Vita, a food product retailer. And the defendant was Madame Zhang Lan, a wealthy businesswoman of Chinese origin, although also a proud citizen of St. Kitts and Nevis, and the settlor of a family trust. The trust was called the Success Elegant Trust, Madame Zhang's family trust, set up for the benefit of her son and her grandchildren, and remoter issue. And importantly, Madame Zhang Lan was not a beneficiary of the trust. Mm-hmm. And then, of course, we have the trustee, which we'll call Settle, the trustee of the Success Elegant Trust. So the background is that back in 2013, La Dolce Vita acquired an interest in companies that were beneficially owned by Madame Zhang. Okay. And that resulted in payments being made by La Dolce Vita to Madame Zhang to her personal bank accounts. And some of those funds then were paid on by her the year later in 2014 to bank accounts with Credit Suisse and Deutsche Bank, importantly in the name of Settle. So not into her own personal bank accounts, but in the name of Settle, the trustee.
Yep.
Now, after the acquisition, La Dolce Vita brought arbitration proceedings against Madame Zhang in connection with the transaction alleging misrepresentation. And the claim was successful. And so La Dolce Vita obtained an arbitration award and subsequently recognition of that award in Hong Kong, and also registration of that in Singapore. And it's a Singapore court judgment that then we are dealing with regarding the trust issues. So in 2020, rolling forward another 6 years, La Dolce Vita sought to obtain an order in Singapore to effectively get their hands on the funds that had been transferred into these two bank accounts in Singapore, one with Credit Suisse, one with Deutsche Bank, that were opened in the name of the trust. So not the defendant to the arbitration, Madame Zhang. Yeah. So the judge had to decide whether Madame Zhang had a beneficial interest in the bank accounts, despite not being the named holder on the bank accounts, which were in the name of Settle, the trustee. That was the critical issue. And the judgment of the Singapore court was given in November of 2022, so not so long ago, and it was held in favour of La Dolce Vita. The court found that Madame Zhang beneficially owned the funds in the bank accounts despite them not being in her name.
Yes.
And there were a couple of really important facts the court took into account when deciding that. The first is that Madame Zhang had used some of the money in these accounts to acquire property in the US, effectively in her own name, for herself. And that wasn't done under the control of the trustee. Yep. And secondly, that she had moved money out of those accounts prior to freezing orders being made against her, And these actions all took place without complaint at the time from Settle the trustee. So those factors led the court to decide that these monies were actually beneficially owned by Madame Zhang.
Understood. So this is fascinating because it's quite rare that you actually get to such a visible court case, and more importantly, that we practitioners can actually then take takeaways out of it. So let's look high level and then a little bit more granular. At a higher level, what are, in your view, the key takeaways of this case in terms of we call that trust busting or structure under attack? What are the big takeaways? And then we'll look at granular.
Yeah, no, that's really important. So, I mean, I think the market has taken real interest in this case, whether you're a high net worth individual looking at asset protection or succession issues, whether you're a trust company, a wealth advisor, or a banker. This case has got your attention. And it may cause concern around the validity or the effectiveness of trust arrangements, but that could well be driven by potentially a misunderstanding of what this case is about. So really, this case does not in any way sound a death knell for common law trusts. I would say the ramifications of the case are pretty much limited to the facts in question, although those facts do give us some interesting lessons about issues that need to be taken into account. So it's in fact not a trust busting case. The real point here is that the money in question, the money that Madame Zhang transferred from her account into these two accounts in Singapore in the name of Settle, the monies never truly reached the trust structure because it was clear on the facts, as the judge found, that Madame Zhang, and not the trustee, still retained control of those funds. As I mentioned, she used them herself to acquire property and move the funds out without Settle's intervention when she wished to do so. So really the key point is the money never really reached the trust structure. Madame Zhang retained control of it.
So this is a perfect segue on the granular question. So you are saying that the proper settlement of the asset is one of the I would say the key focus to avoid, so that we do not fall into a Dolce Vita scenarios. What would be the other elements that you, as practical takeaways, people could learn from?
Yeah, I mean that's really important. I think it's about doing the basics right. And I would say you could look at it in a couple of different stages. The first is to be absolutely clear on how to effectively settle assets into the trust so that you are not, as settlor, retaining legal or beneficial ownership over those assets. That is absolutely key, because if you don't do that, then ultimately what happens later is almost irrelevant because the assets have never reached the trust. Yep. Secondly, it's making sure that once the assets are in the trust structure, they are dealt with, or perhaps importantly, not dealt with in a manner that's consistent with them having become trust assets. So they should remain the assets of the trust and not be used in a way that someone could later say means that they are actually still the assets of the settlor. So it's putting the money in the correct way and then how those funds are used later, making sure the trustee has a proper and effective control over the trust assets. And by doing that, you maximize the prospects of the trust arrangements being valid and therefore the protections and advantages of the trust structure in the first place being effective. Now, it goes without saying that doing that is not always straightforward. And you really do need to have clear professional advice from trust advisors, financial advisors, lawyers potentially, to make sure that those arrangements are put in place and correctly documented, both at the outset and on an ongoing basis. And I'd also say that, of course, there are other structures that you can look at that may well be a better option to a trust, depending upon what it is you're seeking to achieve.
And that's another quite good segue on what is happening here in the local market, because while this case is Asian-based, I think there are some lessons that we can draw to what is happening here. And here in our neck of the woods, We have seen a lot of activity in the legacy planning space of the past 3 years, whether by being using trust or foundation or combination of both. We see that quite a lot these days, but really the lion's share is on foundation at the moment. And if you want to learn more about this, we have one specific episode that touches on that in our library. So last question for you, therefore, is the takeaways that we have now talked about in trust planning in general. How applicable are they to whoever is today setting up, let's say, a foundation or private trust foundation as a trustee for regional assets here in the UAE, whether in the ADGM, the IFC, or RAK ICC? Is there some commonality? Is there any differences?
Yeah, that's a really good question, and I think you've hit on a really important point, which is this part of the world is complicated. So you've got trust laws in the DIFC and Abu Dhabi Global Market that are common law based. Trusts outside of that one in the onshore arena don't really have the same meaning, and there's issues about enforceability and how they're understood. So it's a more complicated environment, and therefore more care needs to be taken around making sure that what you put in place is effective. And then we have, as you say, the growth of foundations, which are much more familiar in this region and are specifically recognised under DIFC law, for example, and elsewhere. So it's a really good option for someone thinking about the sorts of structure and protection that historically maybe people were only aware of trusts as offering. There are some similarities, but also some differences to think about. This case is not a case, the Dolce Vita case is not a case about foundations, but nonetheless, it's a reminder of some really important basic principles. And I would say that really brings us back to the key point about being clear about what it is you're looking to achieve at the outset, and then also the ongoing management issues. But just by way of a quick reminder, the big difference in relation to a foundation versus a trust. If you're looking to put in place a foundation, the founder or the settlor puts in place effectively a council, a management body to manage the foundation.
Yes.
And that can be done in a way that takes into account the settlor or the founder's wishes. So there is an ability for the person putting the assets into the foundation to have some influence over what those assets are used for under the foundation structure. So therefore, more control, one might say, than under a typical trust structure, where the management of the assets is left solely to the trustees. And that's probably the major difference that I would want to highlight in circumstances where you might be a Madame Zhang looking to have some control over assets that you've tried to separate legal and beneficial ownership of.
That's really the balance, yes. So it's this, we discussed that last time. It's you can put the structure together, but then it's always sound to actually have someone theoretically trying to burst it and say how much control is too much. The timing of settling the assets onto the structure is also important. All these elements that needs to be balanced depending on the needs, because some families will just want succession planning, but others will want asset protection from, for example, providing guarantees in the market, etc. So probably a good time to call Stuart and his team for some input, huh?
Absolutely right. I think the big takeaway is there's no one size fits all. You've got to work out what you're trying to achieve and structure accordingly.
Look, Stuart, this was eye-opening as always. Thank you very much for shining a light on finally some interesting piece of recent jurisprudence. Let's see how that impacts the local market. I actually believe positively, because any precedents from a tier 1 financial center that has had a history of fiduciary structure can be a good piece of learning for us here in the DIFC, in the ADGM, in front of the courts. So once again, Stuart, thank you very much. And we will be back next week with, I'm told, a new series starting on foundation and real estate. Quite a topic and a hot one given corporate tax benefits. So we'll talk about it next week. Thank you. Bye-bye.
Pleasure as always. Thanks, Jan.